BrokerCheck disclosure requirements are found under FINRA Rule 8312. Now notice I haven't always been saying the rule number because, once again, just to remind you, every once in a while I'll get feedback from a student that says, I had no references to FINRA rules. None! Which makes, are you kidding? There's like 1,000 FINRA rules on the outline for the test, and she had not one? What are you going to do? So sometimes I'll mention them and sometimes I don't. Don't try to memorize all of them. You will go crazy. In response to a written inquiry, electronic inquiry, or oral inquiry via a toll-free telephone listing, FINRA shall release information regarding a current or former member or current or associated person, current or former associated person, through what's called FINRA BrokerCheck. So this is kind of a unique program. If you have never gone to the FINRA website, I urge you to do so. Right on the home page, at least currently, of FINRA's website in the upper right-hand corner is the BrokerCheck program. So it's actually getting much more publicity as of late than it has in the years previous. This rule is not new. This rule's been around forever. It's just that we're trying more and more, we being, I suppose, FINRA, to make sure that our customers understand they have the ability to access information about the broker-dealer with which they're going to be doing business, as well as access information about the registered person, that's you, with which they're going to be doing business. It's not, the fact that you're a licensed person opens you up for the ability to have lots of things about you disclosed to the public. So how do we do this? So in the old days, before the internet, we called up FINRA. And that's why the idea that the FINRA BrokerCheck phone number is made available is so important. But most of the time today, you're probably not going to call up FINRA. You're just going to go to the FINRA website and you're going to look up. So look up your firm. Look up someone that you're going to work for, just for fun, to see what it has about them. So the information that FINRA BrokerCheck must release, and then some of the information that it can't release. It talks about that it has information for members. So these are firms, members, firms. So all broker-dealers must be members of FINRA, so firms. And it has information about currently registered associated persons. So that's you, once you get registered, as well as, and formerly registered. Not forever. So if you left the securities industry 20 years ago, they're not going to have information on you in there still. But they are going to make information available about a formerly registered person that has not been associated with the member during the previous 10 years. So it's any formerly registered associated person within the past 10 years. So 20 years ago, your information's not on there anymore. Within the past 10 years. So information maintained under the FINRA BrokerCheck program. Any information reported on the most recently filed Form U4, U5, with slight exception that I'll show you, Form U6, which is really a form that's used to report, make an amendment regarding a violation that has occurred. Form BD and Form BDW. Currently approved registrations. Summary information about certain arbitration awards against a member involving a securities or commodities dispute with a public customer. The most recently submitted comment, if any, provided to FINRA by the person who is covered by BrokerCheck in the form in accordance with the procedures established by FINRA for inclusion with the information provided through BrokerCheck. Only comments that relate to the information provided through BrokerCheck will be included. Information as to the qualification examinations passed by the person and the date passed. FINRA will not release information regarding your examination scores or any failed examination attempts. So just the tests that you have passed and the date that you passed them. If someone should call the BrokerCheck toll-free telephone listing, the program would have to disclose whether a particular member is subject to the provisions of the NASD. It's Rule 3010. It's called the taping rule. We'll learn about the taping rule in a moment. Historic complaints are listed through the BrokerCheck program. Information last reported on registration forms relating to customer complaints that are more than 2 years old and have not been settled or adjudicated, and customer complaints, arbitrations, or litigations that have been settled for an amount less than $10,000 prior to May 18, 2009, or an amount less than $15,000 on or after May 18, 2009, and are no longer reported on a registration form, provided that any such matter became a historic complaint on or after August 16, 1999. That's a lot of stuff. Don't worry about that one. The name and succession history for current or former members. Information regarding the regulatory actions reported on the registration form. Administrative information including employment history and registration history derived from information reported on the registration form. So that's all information found through the BrokerCheck program for currently registered persons. FINRA shall release information as required next for persons who are formally associated persons within the past 10 years. If such person, so member or associated person, was ever the subject of a final regulatory action as defined in Form U4 that has been reported to the CRD on a registration form, there's very specific information that the BrokerCheck program will release in regards to a person that is not currently an associated person of a member firm, but was an associated person within the preceding 10 years. So information if that person, as it relates to that person, if they were ever the subject of a final regulatory action as defined in Form U4 that has been reported to the CRD system on a registration form, if the member firm or formally registered member firm or formally registered associated person was convicted of or pled guilty or nolo contendere to a crime, was the subject of a civil injunction in connection with investment-related activity, or a civil court finding of involvement in a violation of any investment-related statute or regulation, was named as a respondent or defendant in an investment-related consumer-initiated arbitration or civil litigation which alleged that the person was involved in a sales practice violation and which resulted in an arbitration award or civil judgment against the person. So those are things that they'll release for formerly registered person. So not everything like they would release for a currently registered person or member firm. So person being broad in this discussion. FINRA shall not release certain information through the BrokerCheck program, such as social security number, your residential history, a physical description, information that FINRA is otherwise prohibited from releasing under federal law, or information that is provided solely for use by regulators. So it's important. I cannot tell you how many times I've read articles about securities-related fraud, and the person involved in the sale of these securities wasn't even a registered person. So this idea that the customer has the right to go into the BrokerCheck program and figure out if this person's even truly registered or not, it's at their fingertips if they would just go look for it. What else can FINRA not release? Information reported on registration forms relating to regulatory investigations or proceedings. If the reported regulatory investigation or proceeding was vacated or withdrawn by the instituting authority. Information reported on Form U5 related to the area of internal review disclosure, as well as the reason for termination that is not found in the BrokerCheck program. It's also true that when Form U5 is filed, it's not available within the BrokerCheck program for 15 days. And granted, I didn't write the rule, but I'm pretty sure that has to do with the idea that the person who is terminated also gets a Form U5 filing, and it's not always done right. So if it's not done right, they have the ability to fix it before it's made public, basically. So it's not reported, it's not on there for 15 days. Also not disclosed, the most recent information reported on a registration form if FINRA has determined that the information was reported in error by a member, regulator, or other appropriate body, or if the information has been determined by regulators through amendment to the uniform registration forms to no longer be relevant to securities registration or licensure. They also will not disclose information provided on Schedule E of Form BD. So, have you ever checked your credit report? Sometimes it's wrong. Same idea with the BrokerCheck program. It's not always right. So, FINRA has rules as far as eligible parties may dispute the accuracy of certain information that is disclosed through FINRA's BrokerCheck program. FINRA will presume that a dispute of factual information is eligible for investigation unless FINRA reasonably determines that the facts and circumstances involving the dispute suggest otherwise. If FINRA determines that a dispute is actually eligible for investigation, FINRA will accept, in circumstances involving court-ordered expungement, add a general notation to the eligible party's BrokerCheck report stating that the eligible party has disputed certain information included in the report. So if it was your report, you're a registered rep and you don't believe the information is correct and you're going through this process, there's a little asterisk that says this is being disputed. The notation will be removed from the eligible party's BrokerCheck report upon resolution of the dispute by FINRA, which would make sense. In disputes involving a court order to expunge information from BrokerCheck, to expunge just means to remove something. FINRA will prevent the disputed information from being displayed via BrokerCheck while FINRA investigates the matter. So if I'm saying take it off, it's not correct, or sometimes there's an arbitration award that offers expungement relief, and if it's on there and it shouldn't be on there, they can't have it on there while I'm saying it's eligible for expungement. If FINRA determines that a dispute is not eligible for investigation, it will notify the eligible party of this determination in writing, including a brief description of the reason for such determination. A determination made by FINRA that a dispute is not eligible for investigation is not subject to appeal. So if that's what they decide, that's what they decide. You can't go to any other authority to overturn that decision. If FINRA determines that the written notice and supporting documentation submitted is sufficient to update, modify, or remove the information that is the subject of the request, FINRA will make the appropriate change. If the reporting entity confirms information is accurate in content and presentation, so if it's eligible for an investigation and they look into it and the information's correct, well then FINRA will not change the information. If they look into the information and it's incorrect, then FINRA will notify the eligible party in writing that the investigation has resulted in a determination that the information is inaccurate or not accurately presented and it has been updated, modified, or deleted. Or it could be that FINRA found that it is accurate and no changes have been made. So they have to tell the party in writing. Or the accuracy of the information or its presentation could not be verified and no changes have been made. A determination by FINRA, including a determination to leave unchanged or to modify or delete disputed information, is also not subject to appeal. So if they say, we're not going to investigate, we don't believe this is a valid claim, then that's that. If they choose to change it, or if they say, no, the information is correct, it's also that. So the BrokerCheck program, go check it out if you've never seen it. It's actually pretty cool. So some federal securities laws are next. The Securities Exchange Act of 1934. So the Securities Exchange Act. So this is an example of one that you're going to need to know a little bit about. So it helps me to remember this one. I call it the People Act. So people do the exchanging of securities. Certainly it's done electronically today, but the People Act, the Securities Exchange Act of 1934, was passed in January shortly after the Securities Act of 1933, which is the Registration Act, the Paper Act. So the Securities Act of 1933 requires that all new issues be registered, defines a prospectus, and we'll talk all about that act in a moment. This one was passed a few weeks later, so one in December of 33, this one in January of 34, and this is defining for you lots of important people. So definitions within this act are important. So it defines an exchange. So an exchange is any organization, association, or group of persons, whether incorporated or unincorporated, which constitutes, maintains, or provides a marketplace or facilities for bringing together purchasers and sellers of securities, or for otherwise performing with respect to securities the functions commonly performed by a stock exchange, as that term is generally understood, and includes the marketplace and the market facilities maintained by such exchange. So the People Act and exchange. So the two big ones that we talk about are the New York Stock Exchange, and then we have the NASDAQ stock market. There's others, but these are the big two that we talk about as far as secondary markets. So an exchange defines a facility. So the term facility, when used with respect to an exchange, includes its premises, tangible or intangible property, whether on the premises or not, any right to the use of such premises or property, or any service thereof for the purpose of effecting or reporting a transaction on an exchange, including, among other things, any system of communication to or from the exchange by ticker or otherwise, maintained by or with the consent of the exchange, and any right of the exchange to the use of any property or service. The term member, when used with respect to a national securities exchange, means any natural person permitted to effect transactions on the floor of the exchange without the services of another person acting as broker. So we used to have seats for the New York Stock Exchange. There were seats, and then those member firms had floor privileges. We don't have seats to the exchange anymore because the New York Stock Exchange is a publicly traded company nowadays. So member of an exchange, that's what that's talking about. Any registered broker or dealer with which such a natural person is associated. Any registered broker or dealer permitted to designate as a representative such a natural person. So a member of an exchange. The term member, when used with respect to a registered securities association. Now remember, Registered Securities Association in the United States, that's FINRA. So we call them really a self-regulatory organization, but feel comfortable and confident that you know FINRA is a Registered Securities Association. So a member with respect to a Registered Securities Association means any broker or dealer who agrees to be regulated by such association, and with respect to whom the association undertakes to enforce compliance with the provisions of this chapter, the Securities Exchange Act of 1934, the rules and regulations thereunder, and its own rules. So all broker-dealers, all branch offices, all offices of supervisory jurisdiction are registered with FINRA. They must be. That's how our industry is set up. People, it defines finally for you, broker. So we talk about you have to have a sponsor to take these tests, and I say you have to have a sponsor, broker, dealer, to take the Series 6, the Series 7, 26, and 24. Broker-dealers act in a transaction with a customer as either a broker or a dealer, not as both in the same transaction. And some broker-dealers act primarily as brokers, and some broker-dealers act as both brokers and dealers. It really just depends upon how the firm is set up. So broker side of the transaction is when they are engaged in the sale of securities for the accounts of others. So we'll sometimes call this an agency transaction, or when they act as an agent. So if they're acting for the account of their customers, for their customers. Then that's the broker side, and they're going to charge, which must be disclosed on the confirmation, they're going to charge the client a commission. When they're trading for the firm's own account, for their own account, that's the dealer side. So the NASDAQ stock market is made up of broker dealers, and it's these dealers who take an inventory position. They're market makers. It's a principal transaction. So they make this over-the-counter marketplace happen. So market maker, principal transaction. That's the dealer side of the transaction. So on a confirmation, the broker, if they act as a broker, if the firm acts as a broker, they must disclose the commission. And if they're a dealer, they have to disclose if they're a market maker in that security. They would charge a markup or markdown when they act as a dealer, but they don't have to disclose the markup or markdown. So we find out what the words finally mean because of what federal securities law? The Securities Exchange Act of 34, the People Act. Issuer is defined as any person who issues or proposes to issue any security. So very broad. Person does not just mean you. So kind of throughout the course so far, I've been talking about a person, and it's really important not just think you. It could mean a natural person, but it can mean a company, government, a political subdivision, an agency, or an instrumentality of a government. It defines a security. So a security is lots of different things. So note, stock, treasury stock, security future, security-based swap, bond, debenture, certificate of interest in or participation in any profit-sharing arrangement or in any oil, gas, or other mineral royalty or lease, collateral trust certificates, pre-organization certificates, subscriptions, transferable shares, investment contracts, voting trust certificates, certificates of deposit for a security, a put, call, straddle. All options are securities, or privilege on any security. It's huge. So there's what we call the Howey test, which says if you invest your money with the expectation that by the management of a third party, you will have more money in the end. And I know when you own common stock, you have voting rights, but how much say do you really have if you own 10 shares of Apple and how Apple is run? None. So you have this expectation that when you buy the stock, that the company will be managed in a way in which the share price will do what? Go up. That's what makes it a security. So all options, which we'll learn about in a subsequent chapter, I promise, are securities, where stocks are securities, bonds are securities, and with your Series 6 license, you can sell mutual funds, you can sell variable contracts, which those are both securities as well. You can't sell anything that trades in the secondary market. So we'll talk and talk and talk about the secondary market, primary market, all of those things come up later on. So it's this introduction, this definition of the word security. Now, I want to kind of expand on that for a second here and show you something. So that was just the definition was found in the Securities Exchange Act of 1934. And then all new issues, so when a share is brand new, all new issues, okay, as a general rule, must be registered. So what that means is that there is a federal securities law. It's the Securities Act of 1933. And this one I remember with this little funny thing called the Paper Act that requires that whenever a new issue is going to be sold, a registration statement must be filed. The registration statement under federal securities law is filed with the Securities and Exchange Commission. All new issues prior to sale must have a registration statement filed with the SEC. It must be cleared for sale by the SEC. They never approve any sort of issue that would open the SEC up for legal liability. They'll simply clear an issue for sale. Why does registration have to be filed? Because the Paper Act says so. The Paper Act also says whenever you sell a new issue, you must give out a prospectus. A prospectus is the most important things from the registration statement. But today it's actually possible when you sell a new issue to give out what's called a summary prospectus. if they can get the full prospectus online, which is very often the way it's done today. So a summary prospectus, which we'll discuss in a few moments, can be given out now with the full prospectus being available online if all the rules are followed. So all new issues must be registered. Open-end mutual fund shares are always new issues. When we have a share that prior to sale must be registered, we call it a non-exempt security. A non-exempt security is a security that must be registered. A non-exempt security is a security that must be registered. Must be registered. Certain types of securities don't have to be registered. So we have a few what we call exempt securities. So exempt securities need not be registered prior to sale. So things like U.S. government securities, they don't file a registration statement. They're exempt securities. Municipal securities do not file a registration statement. They're also exempt securities. So all securities must be registered with the SEC. That's just an overall blanket true statement. If a security must be registered, we call it non-exempt. If a security can be sold without registration, that's called an exempt security. So exempt from the registration requirements of the Securities Act of 1933. Back to the Securities Exchange Act of 34, it defines a person associated with a broker or dealer, or they'll say an associated person of a broker or dealer is who? Any partner, officer, director, branch manager of such broker or dealer. Any person directly or indirectly controlling, controlled by, or under common control with such broker-dealer, or any employee of such broker-dealer. Persons whose functions are solely clerical are not considered associated persons. So I had mentioned that before. Clerical staff is not an associated person. So I had a student once in class and she said, well, I'm clerical. And I said, no. If you're getting your Series 6 license, you go back to work and you tell your boss you are no longer clerical staff. No. She is now an associated person. Within the Securities Exchange Act of 1934, we have rules about registration. It shall be unlawful for any broker or dealer to make use of the mails or any means or instrumentality of interstate commerce to effect any transaction in or to induce or attempt to induce the purchase or sale of any security unless the broker-dealer is registered. So the People Act requires the broker-dealer to be registered in order to engage, registered with the SEC, in order to engage in interstate commerce. We know FINRA requires the electronic registration forms, right? So we talked about the FINRA rules in this area. So what might the test ask you about here? With respect to a firm's registration, so if they're going to sell across state lines, the broker-dealer must not only be registered with FINRA, but also with the SEC, must be registered. Must be registered. So it's still the same form. It's not a different form that's filed. So we're still talking about Form BD. The SEC, once they receive Form BD, within 45 days of the date of the filing of such application, the Commission shall either grant registration or institute proceedings to determine whether registration should be denied. So within 45 days, I would know that. So the SEC will grant registration within 45 days or start a hearing about questioning whether or not within 45 days.